Hey everyone, and welcome to The Explainer. Today, we are taking a fascinating 4,000-year journey back through human history. I want you to think of law as humanity's ongoing attempt to upgrade its operating system for society. We've gone from primitive kinship-based mediation all the way to a highly structured digital-first legal architecture. And honestly, the evolution is absolutely incredible. Here's a quick look at our roadmap. We're going to cover the dawn of ancient codes, the big split between Rome and common law, the global spread of that common law, India's really unique legal evolution, and finally, we'll wrap up with the language of modern law. Let's get right into it. Section 1. The dawn of ancient codes, moving beyond blood feuds. Okay, so before written laws, figuring out right and wrong was basically just about who was the strongest or, who could exact the most revenge. But starting way back around 2400 BCE with the Ebla tablets in Syria, we see something completely unprecedented, the earliest written law archives. Then, around 2100 BCE, the Code of Ur-Nammu takes a huge leap by introducing monetary compensation instead of just purely physical punishment. And finally, by 1750 BCE, Babylon's Code of Hammurabi steps in to fully standardize criminal punishments across the board. Think about what a massive shift this was for humanity. These ancient codes acted as our very first major software update. We can basically call it Justice 1.0. It was this monumental pivot away from just physical retribution and the random whims of local rulers, moving towards state-sanctioned, predictable, written rules. For the very first time, maintaining order actually became a structured governmental responsibility. And that brings us to Hammurabi's most famous principle, lex talionis, or the principle of an eye for an eye. Now, I know that sounds incredibly harsh to us today, but back in 1750 BCE, it was actually a revolutionary step forward. It was designed to limit the scope of private, never-ending vendettas. You couldn't just wipe out an entire family over a stolen sheep. The punishment actually had to match the crime. Moving on to Section 2, Rome and Common Law, Two Paths of Justice. So here is where we see a huge fork in the road that totally shaped the Western world. Over in Rome, in 451 BCE, they created the 12 Tables, their first big attempt to codify law for all citizens. Fast forward to 529 AD, and the Byzantine Emperor Justinian compiles this massive, comprehensive text called the Justinian Code. But over in England, a totally different approach was brewing, especially after the Norman conquest in 1066 AD. Instead of writing a grand, sweeping code from the top down, they started building the law organically from local customs and individual judicial decisions. And this is where we really see that big split. You have the civil law tradition rooted in Rome, which relies on comprehensive written statutes that judges apply directly to cases. Then, conversely, you have the common law tradition rooted in England, which relies heavily on unwritten custom and judicial precedent. Understanding this dichotomy is absolutely crucial because it forms the baseline for our entire global legal landscape today. At the literal heart of that English common law engine is a concept called stare decisis. It's a Latin term, and it means that previous court decisions must serve as binding precedents for future similar cases. So instead of just looking up a centralized statute in a big book, judges look back at how previous courts handled similar disputes. They are effectively building the rules case by case, brick by brick. Section 3. The common law spread. Exporting the framework. So, how did this highly unique English system essentially take over the globe? Well, it was exported worldwide via the British Empire. This common law operating system became the fundamental basis of the United States legal system, and it was integrated into the vast Indian subcontinent. It also brought along this really interesting dual system of rigid law and flexible equity, which basically provided remedies for fairness when a strict by-the-book application of the law would result in a totally unfair outcome. Now, what's super interesting is how the U.S. took that common law inheritance and adapted it by dividing it into parallel state and federal systems. It's a delicate balance of local and national power. State courts handle the vast majority of your everyday civil and criminal cases. But federal courts? Those are reserved for big questions of federal law, or what's called diversity of citizenship cases, like if you have a civil dispute over $75,000 between people from two totally different states. Section 4. India's legal evolution from colonial roots to modern framework. Let's pivot geographically over to India, because their legal journey took a highly unique centralized path. It started with a very confusing colonial patchwork. The 1773 Regulating Act created the Supreme Court of Calcutta, but that actually caused absolute jurisdictional chaos because it constantly clashed with existing company courts. Eventually, in 1861, the High Courts Act merged these rival courts into a unified system. And ultimately, the 1950 Constitution established the modern Supreme Court of India as the ultimate guardian of justice. Unlike the parallel U.S. setup we just talked about, India adopted a single integrated hierarchy. At the very top, the apex, is the Supreme Court of India, the final court of appeal, and its rulings are binding on everyone. Below that, you have 25 high courts serving the states, acting as principal civil courts with writ jurisdiction. And down at the base are the district and sessions courts, which are the very first point of contact for local civil and criminal disputes. But here is the kicker. Post-independence India didn't just passively keep the British courts. They fundamentally upgraded them. In a brilliant piece of legal engineering, the landmark 1973 Kesavananda Bharathi case established the basic structure doctrine. This essentially prevents Parliament from altering the absolute core foundation of the Constitution. They also created the collegium system for judicial appointments to strictly insulate judges from executive influence, all while keeping that massive, single integrated system intact. So why does this matter to us? Well, because India's legal system is this fantastic, ongoing evolution. It blends ancient philosophy, colonial frameworks, and modern constitutional mandates. It's living proof that law is never just static. It's constantly adapting, constantly reinventing itself to successfully govern a diverse, billion-strong democracy. Which brings us to our final section, the language of law, demystifying the modern courtroom. Let's do a quick rapid-fire vocabulary round to demystify things, starting with the two main characters in any legal drama. The plaintiff is the party who actually initiates a civil lawsuit, usually seeking damages for some sort of loss or injury. The defendant is the party who has to answer those civil claims, or if we're talking about a criminal case, they are the person formally accused of a crime by the government. Now, before a judge can even think about banging that gavel, they must have jurisdiction. This is simply a court's legal authority to hear and decide a specific case. If a dispute doesn't belong in a court's specific geographic or legal lane, well, that court simply has no power to rule on it. Next up is evidence. This is the admissible information, think sworn depositions or physical items, used by a judge or jury to actually decide the case. And the rules here are incredibly strict. For example, you've probably heard of hearsay. That rule generally blocks out-of-court statements from being presented as fact, which ensures that only reliable, cross-examinable information actually makes it into the courtroom. And the ultimate goal of this entire massive machine? The verdict. This is the final decision of a jury or judge at the end of a trial. It is the structured, formal delivery of justice that Hammurabi started tinkering with 4,000 years ago, and that modern juries have refined into an absolute art form over centuries. Speaking of juries, here's a wild fact for you. To reach a verdict in a U.S. federal criminal trial, you need exactly 12 citizens on the jury to unanimously agree. Just imagine trying to get 12 complete strangers in a room to agree on absolutely anything, let alone someone's freedom. It's pretty amazing that it works at all. Which brings us to a final, really provocative thought. When we step back and look at this massive sweep of history, from clay tablets in Ebla to fully digital dockets today, is our legal evolution finally complete? Or will future technologies like artificial intelligence or massive societal shifts force the next great update to our laws? Definitely keep that in the back of your mind the next time you're reading about a big court case. Thanks so much for joining me for this explainer.